Hi, welcome to Mondays with Melissa. If you watched Mondays with Melissa last week, you know that we are in the process of answering the top 5 questions regarding elder law, estate planning, and Medicaid. The question for today, question number 2, is what are the most important legal documents that an individual should have when they're considering an estate plan? And those documents are a power of attorney, a healthcare proxy, a living will, and a last will and testament. Sometimes we'll add to that list a trust of some sort, depending on the plan. But when it comes to what's most important, it's really those 4 core documents: power of attorney, where you name someone to handle your financial matters for you if you can't handle them yourself. If you have an illness, an injury, or an accident that causes you to become incapacitated, such that you can no longer handle your own finances, you need to have somebody in place legally that will be able to take those things over for you, be able to communicate with banks, be able to communicate with insurances, with pension companies, with other financial institutions, with hospitals, with nursing homes. Regardless of who it is, you need to have a legal document in place that's properly executed that will allow for somebody to step in and serve as your power of attorney. Now, in New York, you can have 2 people acting. You can require that they act together, or you can state that they act separately. So there are a lot of different ways to set up a power of attorney. It's always good to sit down with us and have that conversation of who makes the most sense to be in that role. The second document is the healthcare proxy, and that's where you name someone to make healthcare decisions for you if you can no longer communicate your wishes. So I always tell people, if you have a terminal illness and you're hospitalized, but you are able to make and communicate your own decisions, your doctor is listening to you. The only time your agent is going to step in is if you can no longer communicate what your wishes are. So in New York, you can only have 1 healthcare agent at a time. So we can put multiple people on the document itself, but only 1 at a time. It doesn't mean that your family members can't make decisions together. It's simply the person that's going to be the person to communicate with the medical staff. So you also want to make sure that you have conversations with that individual so that they know what your wishes are. The third document is the living will. And that's where you state your wishes regarding end-of-life decisions, artificial nutrition, hydration, respiration, what you want, what you don't want. So that document in New York is not necessarily a statutory document. It is a document that serves as evidence of your wishes. It is instruction to your healthcare agent should you be in a situation where they have to make an end-of-life decision. And also it takes the burden off the decision maker to some degree that they have something in writing knowing what your wishes are. And then you have the last will and testament, or the will, which is where you basically lay out what you want to happen to your estate when you pass away. Who's going to, receive your assets? If you have a home, where's the home going? Are you leaving things to children? Do you want to make specific gifts to children or grandchildren? Do you have any items of sentimental value that you want to make sure go to specific individuals? So that is the document. The will, or last will and testament, is the document where you get to get all of your wishes and desires out on paper. It does need to be properly executed, and it's important to make sure you know where that original is. Many attorneys will hold on to the originals in a fireproof, waterproof vault for you, and I think that that's an excellent idea. It's not ideal to put a will into a safe deposit box or anything like that, because you need your executor to be able to access it at the time of your passing. So very important to make sure that you have these 4 documents in place. And like I mentioned, sometimes we'll add a trust, whether revocable or irrevocable, depending on the specific circumstances of somebody's estate. If they're doing asset protection or they need to do some sort of tax planning. But the 4 core documents: power of attorney, healthcare proxy, living will, and last will and testament. And just as an aside, the power of attorney and the healthcare proxy are crucial for anybody 18 or older. So these are not documents you should wait to do until you're older or sick. These documents should be done by everybody once they turn 18, because once you turn 18, There's no one with the legal authority to step in for you and handle your finances or your healthcare decisions if something happens and you become incapacitated. And we all know that anything can happen at any time. So we want to make sure that everybody is prepared and they have all of their ducks in a row. So reach out to us, give us a call. We'll talk about these documents and how they pertain to you. Please make sure to like, share, and subscribe. And as I said, that was question number 2 in the top 5 questions about elder law, estate planning, and Medicaid. So come back next week for question number 3, and we'll see you then.